Good afternoon, ladies and gentlemen, and thank you for standing by. Welcome to today's Brexit and Beyond conference call. At this time, all participants are in a listen-only mode. There will be a presentation followed by a question and answer session, at which time, if you wish to ask a question, you may do so via the Q&A box on the bottom left corner of your screen. I must advise you that this conference is being recorded today, 16th of January 2019. And now I would like to hand the conference over to your speaker today, Mr. Stuart Hopper. Please go ahead.
Good afternoon from London, and welcome to the first in our next series of Denton's Brexit and Beyond webinars. My name is Stuart Hopper, and I'm the Director of Practice Development and Innovation here at the firm. Joining me for some high-level input into what is truly a fast-moving Brexit situation are Michael Dean, a competition partner in our Glasgow office, Jessica Pattinson, head of our immigration practice here in London, and Adam Brown, a managing practice development lawyer in our energy team, also here with us in London. As you'll all have heard, I think last night, at the close of the fifth day of debate, the UK's lower house rejected Theresa May's withdrawal agreement by 432 to 202 votes. This is an unprecedented majority of 230, with 118 Conservative members voting against their own government. This is in fact the biggest loss in modern parliamentary history. And for context, the next largest margin was back in 1924, when a Labour minority administration lost the censure motion by 166 votes, which in that case led to the fall of the government. The Prime Minister now faces a vote of no confidence, tabled by Jeremy Corbyn, the leader of the opposition, the vote on which will be held at 7 p.m. tonight. Soon after voting last night was announced, Donald Tusk, the European Council President, released a communication expressing regret at the outcome of the vote, urging the UK government to clarify its intentions with respect to next steps as soon as possible, and noting that, I quote, "The risk of a disorderly exit has increased with this vote, and while we do not want this to happen, we will be prepared for it." So, how on earth did we get here? Well, when the original referendum vote was announced back in 2016, and we ran our first set of Brexit webinars, our panel agreed at the time that three things were crystal clear then. 2.5 years later, it seems that for better or worse, each one of those still holds true. Namely, one, that a majority of the British people who voted had chosen by a slim margin to leave the European Union. Two, that the latest figures, which we've updated for 2017, confirm that exports to the EU were still 44% of all UK exports, while imports from the EU remained at 53% of all UK imports. And thirdly, in spite of the above, we were then, and still are now, not sure exactly what will happen next. Straight after the referendum vote, volatility ruled. More than $2 trillion of value was wiped off markets around the world in the immediate aftermath. On the currency market, sterling hit a 30-year intraday low at 131, which was a drop of 14% from the high of 150 it touched on shortly after the polls closed on the Thursday before the vote. Put another way, on polling day, the Leave campaign reminded us that Britain was the fifth largest economy in the world and could look after itself. By the following afternoon, the UK's currency had been sufficiently humbled that we'd fallen to sixth behind France. Since then, the sterling exchange rate has continued to act as a lightning rod for investors' views on Brexit. Last night it dropped and then rebounds sharply in volatile trading following the government's defeat, falling as low as 127 immediately after the results were read in Parliament. It then rebounded almost immediately afterwards, and when I checked just now, sterling is currently hovering around the $1.29 mark. But again, it has fallen as low as 125 in December 2018. This drop, which is a further 6% year-on-year fall, represents an incredible change for a major currency and gives a stark example of one of the concrete effects that Brexit uncertainty has had on the UK and its economy. This uncertainty has made it extremely difficult for UK businesses to plan around the impending changes, with the lack of clarity especially problematic on at least three separate fronts. Firstly, the future and timing of the UK's trading relationship with the EU. Second, the shape of any regulatory framework. And third, the acute and ongoing domestic political uncertainty. all of which prompted firms to stockpile resources, delay investments and their hiring decisions, or even relocate some of these to the EU, while the elevated financial and market volatility has certainly damaged business confidence, reflected in countless business barometers and surveys. It seems obvious that the last of those factors is probably the one that's been driving all of the others. With 72 days left and counting until the UK leaves the EU, it's fair to say that the dial simply has not moved on the politics of Brexit. And it is this which is at the root of the uncertainty around the whole enterprise. Having lost the vote on her carefully crafted 585-page withdrawal agreement, painstakingly negotiated over 18 months, Theresa May's handling of the politics of Brexit has plunged the country into what can probably be described now as a full constitutional crisis. With that said, I wonder whether we could start with some thoughts on some of the political and constitutional issues now in play. With the government facing a vote of no confidence this evening, what does that actually mean, and how does it work? Adam, I wonder if I could pass that over to you for a bit more background.
Thanks, Stuart. So Mr Corbyn, then, as the leader of the party with the second largest number of MPs, thinks that the solution to the problem of Brexit is for his party to form a government and negotiate what he thinks would be a better deal with the EU. But to do that, he's first got to win a general election. A general election isn't scheduled to take place in another 3.5 years, so his easiest route for bringing about a general election now is to win a vote on the motion of no confidence that he's tabled yesterday evening and is being debated today. If he wins that vote, Mrs May and the Conservatives have a choice. They could call a general election straight away, effectively sort of throwing in the towel. Alternatively, they could take advantage of a 14-day grace period that the Fixed Term Parliaments Act of 2011 allows to governments that lose a confidence vote. Now, what are they going to do in those 14 days? Well, they could change their leader, or they could agree a new approach to Brexit. Both those are perhaps unlikely. And even if they do one of those two things, they've then got to go back to the House of Commons and win a vote of confidence. Otherwise, a general election follows. I think it's fair to say that most people assume that the motion of no confidence today will not succeed. So that's that. In any event, there are problems with having a general election as a way of resolving what to do about Brexit, not least that unless the election results in a big majority of one party, you will then have, we could end up in the same position we are now, of sort of struggling to find a way forward. Also, a general election is hard to narrow down to one issue, even if it's as big an issue as Brexit. As a way of finding a popular mandate, it's perhaps not as good as a second referendum, which is what some of the people would like. And then again, also, the election process would take 5 weeks or thereabouts. So while the election is going on, it's hard to have meaningful discussions with Brussels, and the new government would therefore, once elected, only have about half as much time as the government does now to come up with something better than the current withdrawal agreement. So when Mrs May rose to her feet after suffering this great defeat last night in the House of Commons, she made the point that the vote had told her very clearly what MPs don't want. They don't want her agreement, but it didn't say what they do want in its place. Now, of course, what they voted on was a package, both the withdrawal agreement and the political declaration on the UK's future relationship with the EU. And a lot of the recent arguments have been over the withdrawal agreement, and in particular the so-called Irish backstop, which we'll come back to. But I think in a way, perhaps what a lot of people are reacting against is that the whole package as a whole doesn't really settle anything. And in particular, the political declaration, it's a sort of carefully crafted heads of terms that provides cover, over the course of the negotiations that would take place over the next few years for almost every conceivable outcome in terms of what the UK-EU relationship would be in the future. But it doesn't commit firmly on either side to agreeing on any one particular version of what that future should be. Now, one proposed way forward has been set out in a bill that was published yesterday by a cross-party group of backbench members of Parliament. And what that does is to give the government until the 11th of February to get parliamentary approval for the withdrawal agreement again. And then it tasks a parliamentary committee with devising a plan B and gives them until the 5th of March to do that. And if they fail to do that or can't get that plan approved by the Commons by the 7th of March, then the Prime Minister has to seek an extension to the period under Article 50, and so that we wouldn't crash out at the end of the EU at the end of March, but it would be extended until the 31st of December. Obviously, that requires the agreement of the EU to achieve that. Now, this is just an idea that some, albeit a relatively influential group of MPs, have come up with, and whether that anyone else will go for that is not clear. But it's sort of another way forward to try and find out what a majority of MPs can agree with rather than disagree with.
Thanks, Adam, for that crisp summary. Michael and Jessica, I don't know if you've got anything to add. I'm going to pose a slightly cheeky question now. Feel free, any and all of you, to jump in. So, for example, on one interpretation, Theresa May, having won the backing of her party in its earlier confidence vote in December, she is in effect untouchable as leader of the Conservatives for the next year under the party rules, or potentially even to the end of this Parliament in 2022. And she knows that. She also knows that her deal at the moment is the only one in town. Going back to Adam's point, there is no other. People are very clear on what they don't want, but the withdrawal agreement is the only deal in town. And there simply aren't enough votes in Parliament to allow a no-deal Brexit at this point in time. So, assuming that she survives the no-confidence vote tonight, is brinkmanship the name of the game from her point of view? And could we surmise that her plan is just to bring back her deal or a variation of her deal? I think in the debates around the no-confidence motion this afternoon, it's fairly clear now that her red lines announced previously still remain as red lines. And so that there potentially might be an argument that she'll just keep bringing back this deal until it's passed. I don't know what people think about that. Does that sound like it may be an approach that she is taking?
It's Michael here, and I think there's no other deal that she's able to bring back, it seems to me, and given the timescales, and because that withdrawal agreement, from everything that the member states have been saying and the European Union have been saying, that is the deal, and the changes that various parliamentarians and others would like to see in that deal, it's not going to be made, it's not going to be opened up. But obviously there's concerns that some have in relation to the deal that could be allayed through some further additional element which would perhaps appear in a revised political declaration, which is certainly a much more flexible document. And obviously they have received some comfort in recent weeks. Mrs May received that, but it's not enough. So there may be more to come on that front.
Thanks, Michael.
It's Jessica here. So my view on this is that anything that Theresa May is able to get from the EU is really going to be tinkering around the edges, and the deal is the deal. And I absolutely think that there's a chance that what will be presented to Parliament is going to be more or less the same that has already been presented to Parliament. We may be in a position that we're in the game of chicken, and it's, well, this is the deal, you have this deal or you have no deal. I think the other thing that is becoming possibly more of an option is that Article 50 will be extended, and certainly after the vote last night there were some calls for that to happen. So that will certainly be interesting to see if this is all sort of pushed back another couple of months to buy more time for something else to happen.
or even to buy more time for the same thing to just be put back and back until people just
certainly a possibility.
Give up and go away.
Persistence works.
Yes, yeah. Well, truly a messy situation. I suspect we could probably discuss the permutations here for an awfully long time, but I did want to bring the conversation back from the constitutional and political to the practical, at least briefly, if I may. Michael, I wonder if I could ask you to perhaps summarise the current legal position around the, I suppose, newly rejected withdrawal agreement deal and no deal scenarios, and what that means in terms of Brexit options at the moment.
Okay. Under both current UK law and EU treaty law, Article 50, if there is no withdrawal agreement that is approved by Parliament, then we leave the European Union at 11 o'clock UK time, midnight Brussels time, on the 29th of March, and that is exit day under the European Union Withdrawal Act of 2018. So that is the no-deal scenario. So that is the position at the moment. There is no withdrawal agreement which has been agreed by Parliament. So we will crash out unless there is some of the options that have been mentioned before, actually some intervention. And obviously that's the sort of no-deal scenario, and it's in law, and you'll hear politicians such as Rees-Mogg last night stating that Parliament has agreed to a no-deal by putting in that we leave the European Union on a certain date at a certain time, 29th March. And that's one way of looking at it. But obviously, the alternative is, of course, leaving under some form of withdrawal agreement. The great advantage of that for many, in particular businesses, is that it would have a transition period, but of course that's just been rejected, and therefore we need to find some way of assuming most people do regard the idea of crashing out without some form of transition agreement, some form of saving agreement, as deeply unhelpful, let's put it mildly, to business. So we've had the one meaningful vote. It may come back again, and so we may end up with an agreement which gives us a transition period. Now, if we have the withdrawal agreement, then, as I mentioned, there would be a transition period of, at the moment that period in the agreement is for 21 months. There are possibilities to extend that 21 months to the end of December 2020, and in effect that postpones what would be the effect of UK exiting. The UK exits as a member. If we have a withdrawal agreement, and okay, this agreement at the moment looks dead in the water, but if we did go down the withdrawal agreement in a very similar way to the draft that was voted on last night, then the UK would cease to be a member of the European Union, but in all respects, virtually in all respects, the effect of European law would continue, both in terms of European law and European institutions, except the UK would not have any say in what those European institutions were deciding, be it on standards or other laws or technical regulations. Hence the term vassal state. There would be a taker of rules during the period of transition. And of course, during that period, as Adam mentioned, that is the period for actually getting agreement during that 20-month period, maybe longer, or a series of agreements on our future trading relationship. So that of course is what everybody was hoping in concept for a transition period that does allow business some certainty, that does allow us to know where we're going to transition to in terms of relationship with the European Union. But at the moment, that has been The version that we've got in front of us has been rejected. The European Union has said it's not going to change that agreement, and the member states are right behind that. And really the only changes that are likely in the next few weeks are either the UK's position in some dramatic sense or a change in the political declaration, but there's no guarantee that that's going to satisfy the requisite number of parliamentarians. And of course, if we don't have a withdrawal agreement, we have, as Adam referred to, the cliff edge that we are getting closer to, and the ground is getting a bit steeper as we're getting closer to it, and that is us exiting with no provision for the entire withdrawal of the UK and withdrawal of UK regime, citizens, businesses, institutions from the European Union. And that, with no transition, from the 1st of, or the 30th of March, we would be outside the European Union, and there would be a large degree of chaos as to what regime applies. Obviously, if you were heading towards that, one would expect some form of reaction from both the European Union and the UK to try and avoid any either security issues or risk to life issues. That would seem a sensible thing to do. But otherwise, there'd be no framework certainly no framework for the future relationship. The political declaration would be a bit of a dead duck. The UK would run its arrangements with the rest of the world on World Trade Organization terms, and the rest of the world would include the European Union. So freedom of goods would end, citizens' rights, of course, I'm sure we'll come on to that. And of course, we would have an obligation and an interest in having customs borders, tariffs, understanding what's going in and out, and what we're imposing on goods, checking of goods, etc. And that would be between the UK and the European Union, and of course the UK and the rest of the world. And talking about the rest of the world, of course, the UK trades at the moment on a host of European Union free trade agreements, and the UK, of course, would not have the benefit of those free trade agreements. That would mean in the run-up to a cliff edge Brexit, crashing out Brexit, one would be concerned as to whether the goods that were being contracted for supply would be regarded as European Union goods under the rules of origin of the particular trade agreement, what tariffs might apply to them, and the rest. So there'll be some uncertainty on trade on that front. But of course there'd be customs checks, maybe technical requirements, type approvals, regulatory standards that would need answers to in terms of the treatment of goods. And whilst the UK could take a reasonably relaxed, well, not relaxed is not the right approach, but a flexible approach to ensure trade happens, that's not to say that the European Union would take a similar view. And of course, third countries, even under the withdrawal agreement, actually, the EU asked third countries, basically asked them to note that the UK should be treated for the transition period as if it's a member of the EU, so that the UK would enjoy the EU's free trade agreements with third countries. But there's no guarantee that every country will accept that, though many would be happy to do so. So those are the thoughts on what we've got in front of us in terms of no deal and a possible agreement that gives us some sort of transition to another relationship.
Great news. Thanks, Michael. So in summary, the UK is out on World Trade Organization terms unless we can agree some form of withdrawal agreement before the 29th of March.
Or a delay.
Or a delay. Yeah. And,
which requires unanimity by the member states.
I wonder whether we could actually, let's unpack that a bit more. Adam, do you want to say something about possible options to extend the current Article 50 period?
Sure. So, the Article 50 period is a period of 2 years from when we gave our notification of intention to withdraw, and that, when that ends, we either, crash out or go into whatever the withdrawal agreement says. And there are really two ways in which we can get out of this, what was called in one of the early pieces of litigation on Brexit, the speeding bullet of Article 50, which is going to result in something happening once those 2 years are up. And one is the possibility of agreeing an extension to Article 50, as Michael's already mentioned, but that does require all the EU member states to agree that, and one can't have the feeling that they're only going to agree an extension if they think we will make productive use of whatever extra time we're given to get to a better place than we are in now. On the other hand, and I mean things like we're having a general election, we're having a second referendum. You can imagine those would be possible acceptable reasons for being granted an extension. The other possibility is that unilaterally we revoke the notification that was given just under 2 years ago, and the whole process just shudders to a halt. And this is something which was, in the early days, the government was very, very strongly maintained the line that that could not be done. The notice was irrevocable. But thanks to a case that was brought by some members of the Scottish Parliament, that was decided very quickly at the end of last year by the European Court, we now know that it is possible, as a matter of European law, to revoke the Article 50 notice and bring everything to a stop. The court did, however, say that if this was being done, it would have to be done unequivocally and unconditionally. In other words, you can't just sort of play games with this. Now, I guess there would be a question as to how. What kind of state of mind the government has to when it revokes the notification. It's sort of you can say, well, we're bringing this process to an end. We might come back and give the notice again after all. But it could be something which could be used as an emergency brake, possibly in certain circumstances. But probably more orderly would be to do it with an EU agreement to extend the period.
Thanks, Adam. So again, just summarising, revocation of the Article 50 application is something that we could do unilaterally, and as Adam said, there is probably a requirement or a condition of good faith and sincere cooperation around that. And I think that point was raised again in the debates leading to the vote over the last couple of days. So revocation is something that we could do unilaterally. An extension or an application for an extension of time requires unanimous EU 27 consent. So that is something we couldn't do of our own volition or obtain of our own volition without acquiescence from our partners in the EU, our current partners in the EU. One of the sticking points, and we've started to touch on this, I just wanted to come back, that proved impossible for the government to overcome in the parliamentary debates on the withdrawal agreement, was the question of the Irish backstop. And again, I wonder whether we could explore this in a bit more detail. Michael, do you want to take us through this and why it's proving so contentious?
Well, it's both, in terms of pure politics, it's contentious, of course, because the government, ultimately the government is reliant under its confidence and supply agreement with 11 members of the Democratic Unionist Party in Northern Ireland. So they have very strong views on issues in relation to Ireland and Northern Ireland in particular. So that has meant there's a degree of a lack of flexibility from the government's part because it fails if it loses its partners, as it were. But the Irish backstop, as it's called, all parties have agreed, for reasons arising out of the 30-year troubles, you could call it, or insurgency, or low-level war that we had in the UK, in that part of the UK called Northern Ireland, primarily, which cost 3,000 lives. All parties realised that the agreement that brought that to an end and had decommissioning and various other provisions in it, and various constitutional changes, the Good Friday Agreement of 1998, that shouldn't be endangered, and we shouldn't be taking a step backwards on that, and that one of the aspects of the solution to that period of trouble was the fact that European Union membership meant that economically, and to a degree for people as well, it was irrelevant for those nationalists who wanted a united Ireland, and for unionists who wanted to remain part of the UK. That sort of distinction was eased by being members of the European Union, and so therefore there is actually a lot of business going backwards and forwards throughout the island of Ireland in services, goods, and it's almost an indistinguishable border, and nobody, none of the parties believes a physical set of infrastructure should be put up along that 500-kilometre border. It's a very long border. It's virtually unpoliceable. But nobody believes that under any circumstances there should be physical infrastructure, because it will attract the potential to attract terrorist activity, and so therefore there is this agreement between the UK and the EU, and it was one of the EU's primary concerns in its negotiating mandate, was ensuring there was no hard border, no physical infrastructure between Northern Ireland and Ireland. And of course, that border is the only land border between the European Union and the United Kingdom. So given that we've agreed there's to be no border, no physical infrastructure as such, then during if we end up, if the political declaration on the future relationship allows us to have a situation where we have very free trade, very much aligned standards across a whole raft of issues, then that would suggest that there would be almost no need for any infrastructure on the Northern Ireland border. And that would be a happy place to get to vis-à-vis, of course, that border. However, there is a possibility that during the transition period or after it, the negotiations wouldn't get that far, and therefore the UK would tend to have a border with the European Union, which did have friction, which did have physical infrastructure and the like, and of course that implies that there should be some physical border in Ireland, between the North and Ireland. And so therefore, given those concerns, basically the parties that agreed a legally binding insurance policy, which was set out in the withdrawal agreement, a protocol, just to ensure there be no hard border in that event, all parties agreeing that that's something they would want to avoid, and in fact they wanted to have no need for a hard border by having frictionless trade, etc. However, if that cannot be, that agreement, that trade agreement with the EU cannot be reached, then the backstop in the withdrawal agreement provides that, certainly to a degree, that the UK itself would be required to maintain certain standards of environmental protection, social and labour for the period that it was required. And in particular, as regards Northern Ireland, there'll be a whole raft of regulatory and technical responsibilities out of EU law that Northern Ireland have to continue to abide by, provisions on goods, They would have customs legislation, EU customs legislation applied on it, EU rules on VAT and excise. They would have additional rules binding Northern Ireland into the state aid regime, and also any goods manufactured in Northern Ireland would have to be marked, labelled as UK Northern Ireland, for example. And also there would be the European Commission would have a role in overseeing Northern Ireland in those aspects under the backstop, and the European Court of Justice would have jurisdiction as distinct from the rest of Great Britain. So the period of that backstop, you would have a different treatment to Northern Ireland than you have in the rest of the United Kingdom. And that, of course, is not something, a distinction that unionists, those who want Northern Ireland to remain part of the UK, would want to have. Also, constitutionally, it was just seen as not acceptable to have a part of the United Kingdom within the European Union's jurisdiction as opposed to the UK Parliament. Also, the Northern Ireland would very much more than the UK be a vassal state, if you like, a vassal taking rules that they don't actually participate in. So that's the backstop, and it's an insurance policy. In order to get, having postponed the meaningful vote from December, Theresa May tried to get some comfort on the backstop from the European Union, and letters were issued by the Commission President, the Council President, Juncker and Tusk, respectively, making clear that they regard it as a temporary issue, that they don't want to see it enter into force at all, and they want to see it replaced, obviously, by a trade agreement which obviates the need either for the backstop or indeed for physical infrastructure on the border. So that's where we are in terms of the backstop.
I think it's fair to say, Michael, that as you say, it's an insurance policy, the backstop, from the point of view of Ireland. It's been described by the government in its own sort of slides, presenting the deal as, it's deliberately uncomfortable for both parties. I mean, at the end of the day, it's a bit of a lever, and it's a lever really in the EU's favour in sort of the negotiations on a future relationship, because to the extent that the UK really doesn't want to be in that world, it gives an incentive to reach an agreement on the future relationship, sooner rather than later, because otherwise you tip into that backstop, which, although it's expressed to be temporary, there's nothing in it to stop it lasting indefinitely if no agreement is reached.
Thanks. The other thing I'd just say, it strikes me as ironic that the DUP, whose votes the government relies on to keep it in power, their views don't actually mirror those of their constituents, because Northern Ireland as a whole voted to remain and are now represented by some of the hardest, I was going to say non-remainers, but I'm not quite sure, hardest and most hard-line group or block of votes in Parliament. Now, I know, Michael, you talked a bit about sort of general trading arrangements earlier on and touched on some of the ramifications under the backstop. I'm very conscious that some thoughts from us on employment law and labour mobility will probably be appreciated by our audience. So again, if we can take it from a trade and goods to people issues, Jessica, I wonder if you could give us a few of your thoughts on those.
Absolutely. So I thought we'd start with employment and pensions law before we move into the more difficult topic of immigration. The good news is that in either scenario, so a no-deal or the withdrawal agreement, there will be very little impact for employment and pensions law. The European Union Withdrawal Act of 2018 transposes the vast majority of current EU law into domestic law. So all of the current employment protections which stem from EU law will be preserved. However, under a no-deal scenario, there are two relatively minor areas where there will be a no-deal impact. The first being existing European Works Council rights, They will be protected. However, no new request to set up a European Works Council or information and consultation procedure will be permitted. Requests for information or to set up a European Works Council, which has been made but not completed before exit day, will be allowed to complete. If you do have a European Works Council in place, we do recommend you review the agreement given that there will be no reciprocal arrangement between the UK and the EU after exit day. The other point to note is that if a UK employer is insolvent, UK and EU employees working for the employer in an EU country may not be covered under that country's national guarantee fund. The government has confirmed that employees living and working in the UK for a UK or EU employer will continue to be protected in the same way as they are now. However, whether EU and UK employees working in an EU country for a UK employer are protected will depend on how that member state has implemented the insolvency directive. Moving on to immigration. Immigration has been a very contentious topic throughout the Brexit referendum debate and the subsequent withdrawal negotiations. But it is one of the areas that actually we know the most about, and we have a degree of certainty in some areas, with the most important point to note being that EU nationals and their family members who are already living in the UK or who arrive before exit day will be able to stay regardless of whether a deal is agreed or not. In either scenario, EU nationals and their family members will need to apply for new residence documentation to be able to remain in the UK, and the government has set up the EU settlement scheme for this purpose. The scheme is due to launch the day after Brexit, so the 30th of March 2019, but there have already been a number of pilots, and a number of applications have been processed under that scheme. The next pilot is actually due to run from Monday the 21st of January, and that will be a public testing phase of the system. So you may find that people are already applying for this residence documentation that they need to be able to remain in the UK after Brexit. While the processing of applications under the EU settlement scheme will be the same regardless of whether we have a deal or no deal, there are some key things that EU nationals and their employers need to be aware of. Under a no-deal scenario, the deadline to apply for that residence documentation is 6 months earlier. So in a deal scenario, the deadline to apply is a very generous 30th of June 2021, whereas in a no-deal scenario, that deadline will be still, a lot of time, the 31st of December 2020. The other big difference for EU nationals is that their ability to bring family members to the UK after Brexit will be very different under a deal to a no deal. In a deal scenario, the ability to bring close family members to the UK continues. It will be possible to bring close family members to the UK into the future under the more favourable EU system, where you simply have to show that you're a close relative and that the relationship existed on exit day, or in the case of children, children born after exit day. In a no-deal scenario, that ability to bring family members to the UK will only continue for 3 years, so until the 29th of March 2022. After that time, for an EU national to bring family members to the UK, they will need to do that subject to UK domestic immigration law, which is very, very different to the more favourable EU system, and a lot of people will find it very difficult actually to bring family to the UK under that system. The greatest uncertainty surrounds EU nationals arriving in the UK after Brexit in the event of a no deal. We know that in the event of a deal, we have the transition period for 21 months, and that free movement will continue for that period. In a no-deal scenario, we don't have that transition period, And certainly the question that I'm getting most often for people is, well, in a no-deal scenario, what happens on the 30th of March if an EU national wants to come and work in the UK? And a simple answer to that question is that we don't yet know. The government published its long-awaited immigration white paper on the 19th of December 2018. But this white paper was very much for the future immigration system, so intending to come in after the proposed transition period that we would get with a deal Brexit. It didn't deal with what would happen in the event of a no-deal Brexit and needing to have an immigration system ready for the 30th of March 2019. The immigration white paper proposes extending the existing points-based system to cover EU nationals, but to make a number of changes, such as abolishing the resident labour market test and also reducing the skills threshold to open up the work permit regime to a greater number of jobs. It's unlikely that, even in best case scenario, that this new immigration system would be ready even for 2020. The government is planning a 12-month period of engagement and consultation on these proposals. So, it is a long-term plan. As an interim measure, one possibility is that the government will pass some emergency legislation to allow some form of immigration route for EU nationals to continue coming to the UK. But I think until we have certainty around the withdrawal agreement and the voting that will take place next week, I don't think we'll start to see what any of that looks like.
Great. Thanks, Jessica. I'm very conscious that this is a Q&A session as well, and we've got a fair few number of questions coming in. If I can take maybe the first one. The question is, are you expecting change of law provisions to be invoked in contracts, and in relation to what key areas? Adam?
Yeah, I mean, that's obviously Brexit is a pretty big change in law in itself. Although it's of a peculiar kind, because, as we've said already, what the European Union Withdrawal Act of last year will do is to kind of take EU law frozen at that moment in time of exit and turn it into equivalent UK law. That's not as simple as it sounds, but obviously down the line there'll be departures from that frozen version of EU law, and other consequences of Brexit could be treated as change in law, and people, I suspect, who find themselves economically disadvantaged by Brexit might use a change in law clause to try and restore their position against their contractual counterparties. But then you have, in most change in law clauses, drafting around foreseeability. This thing has been coming down the tracks for a while, so arguably it's foreseeable, and so maybe filtered out for that reason. And at the end of the day, most change in law clauses take you towards a negotiation and having to agree something different. They don't necessarily get you out of jail free, as it were. So yes, I think they're certainly a good thing to check over, particularly existing agreements or things that are being drafted now. But they're not silver bullets for Brexit.
Thanks. Just looking on the screen again. Another question. What should those entities negotiating new contracts with cross-border elements be aware of? Michael, is that something you want to review?
Yeah, to a degree. We referred to a couple of elements that, and of course, depending on the contract, the nature of the goods or the services that you're talking about, envisaging the worst case scenario and how would the parties be negotiating if there was a worst case scenario. Actually, would you do the deal if there was a worst case scenario? And who's going to bear the additional cost of delay, costs of if there's stockpiling required, if to undertake to deliver over the period of exit day, without any delay built into a contract might be a bit risky, depending on the means of logistics used. In addition, one would be thinking about are there going to be any regulatory issues in terms of the goods involved. In fact, do you also, in terms of contracting to supply, have a supply chain that you need to know that they're going to be able to help you fulfill your contract, or is that something you're going to be able to draft in to excuse you from failure to comply, or the other parties failure to comply to deliver to you? Data, where is the data? Can you get access to it if you're on the other side of a barrier? In terms of the EU's GDPR rules, or even regulatory data, if you're talking about chemicals and files that you need to show compliance with a particular regime, such as the chemicals regime, type approvals, get them approved. Particularly, I think, if you're moving from the UK, goods from the UK into the EU, the UK will have has promised, in the event of no deal, a bit of a transitional period in some respects for some of these issues. But it's thinking through those issues and trying to build in for neither party to be crucified if we end up with a crashing out Brexit, and you're still both parties want to do the deal. If there's mergers, that are being contemplated, maybe there's a bit techie in the competition field, but if the EU is looking at a merger, or if you're going to be notifying a merger to the EU under the EU merger regulation, you may also have to notify and think about that in the UK as well. And in fact, the Competition Markets Authority are shadowing mergers. They're keeping an eye on mergers that may fall into their lap if we exit the EU regime at the end of March.
Thanks, Michael. Conscious that we are pushing up against the end of this, so might just do maybe one or two more questions. We had one in which I think I like the look of. I'm going to read it out. A spoonful of sugar helps the medicine go down, goes the song. What sugar options are there to convince the Parliament to accept a softer Brexit, close to, but not identical to Mrs May's rejected withdrawal agreement? I'm going to throw that open. Does anyone want to have a go at that? I might just sort of add a wrapper. So does that mean softer Brexit close to, or a harder Brexit? But anyway, what sugar options are there to convince Parliament, I suppose, of anything to move this thing along?
I think, clearly what we're in now is Mary Poppins, but
some magical thinking.
Yeah, I think the difficulty you have is that the song assumes that everyone likes sugar, and what we have in Parliament is a very different number of sweet tastes, and the reason the vote against the deal was so big last night is because it annoys different people in different ways. The people who really want Brexit find objectionable things like the backstop, which potentially ties too much to EU regulation, even for a short period of time. The people, on the other hand, who didn't want Brexit in the first place, look at the withdrawal agreement, see it's 585 pages just to get us out, and a political declaration which doesn't show us exactly where we're going to, but they know, as far as they're concerned, that wherever we end up is going to be, at best, only second best to where we are now as members of the EU. And so finding something which will be a sweetener for enough people with very different tastes is hard.
I think if something happens like Theresa May agreed to stay in the customs union, that may win some votes, but at the same time, there'd be every chance that she would lose other votes.
Well, I mean, it's interesting because that was the part of the amendment that was put down by Jeremy Corbyn yesterday, but not voted on because they wanted to see how big the protest vote would be against the thing. So didn't.
I think it was also one of the points he made in his reply, wasn't it? Saying his three red lines were customs union and freedom, settling the status of EU nationals, and I've now forgotten what the third one was, but that was definitely one of them. Final, I think, question, which I think also has an obvious person I'm going to put it to. What might all of this mean for Scotland and or Scottish independence? Michael, do you want to take a stab at that?
Scotland likes the idea. It depends who you. If you're one of those who would like to see Scotland as an independent state in the future, then you like the idea of a differentiated solution for Northern Ireland. You want the same sort of differentiation. These sort of issues there, and of course Scotland. It's difficult to generalise, but certainly was much more in favour of remaining in the European Union. There wasn't one single voting area, certainly in the mainland, not one single voting area voted by majority to leave. So, and certainly the Scottish Government wants a second. They want a second EU referendum, and in due course they want a second independence referendum, and of course a second EU referendum is a good precedent for having a second independence referendum. But it is very similar sort of issues as in the rest of the UK, but broadly with more of a slant to remaining in the EU, and maybe for many people who voted against independence in 2014, they voted against independence because they wanted to not leave the European Union. Some certainly did. And so being dragged out of the European Union, and particularly by a parliamentary process that does appear a bit dysfunctional and a bit foreign in many ways, some of the characters that play out in Westminster appear a little bit foreign. It maybe plays into independence hands, but it's crystal ball gazing. Tartan ball gazing.
Thanks. Final one, and I'm just going to go around the room, ask you for your very one line on this. The question is, the obvious solution is a new vote. How likely is this? I'm assuming, to keep it simple, that this is a new vote on or a people's referendum. How likely is this, Adam?
Well, I guess it's a bit more likely than it was a couple of days ago.
Jessica?
I still don't know whether it's possible, as much as I might hope that that's the direction that we're moving in. I don't think we're ever any further forward on knowing what the question on the referendum would be. So possibly more likely, but still many barriers to get through to get to that point.
Great. Michael?
Very difficult for Theresa May to do that. She's been totally against it, but you can never rule it out. She changed her mind on a few things, but I think it is more likely. But we're running out of time, and for some, they think that's a great thing, and others, of course, is a great source of worry. But we are running out of time, so we need more time and new thinking and a bit of a shift. And of course, it doesn't necessarily mean that we're going to resolve the issues, even if we have a second referendum.
Thank you all. Well, that is it for our time today, slightly over. I'd like to thank Jessica, Michael and Adam for their time and insights. As a reminder, if you have any questions that we didn't manage to get to coming out of this session or around the whole Brexit situation, please feel free to contact any one of us, your usual Denton's office contact, or Damien Taylor or any of our business development team, whose details are on our Denton's Brexit site. Finally, just to let you know that we will be holding a series of further sessions over the course of the coming weeks to get into more of the detail around some of these issues, or in fact new issues as they develop. We hope you can join us for those as they are scheduled. And thank you all.
Yeah, and
Ladies and gentlemen, this does conclude your conference for today. Thank you very much for participating. You may now all disconnect. Enjoy your evening.